you have legal questions. Amy the attorney has the answers. Welcome to today's show. And here's Amy.
Hi, this is Amy the attorney, and I am here with my friend Betsy Lynch, who is going to talk to us today about bankruptcy. More specifically, she's going to talk about consumer bankruptcy. She has been doing this area of law for quite some time, is very knowledgeable about it, and we are excited to have you here.
Thank you, Amy. I'm excited to be here. I love talking about this stuff, and I really love helping people. So it kind of gets to combine both of those things.
You know, I have noticed in my interviews when I've started to interview people is I'm basically interviewing people that like to help people. And even though we're lawyers, that's what we like to do.
Exactly.
Yeah.
Exactly.
All right. Okay. I'm going to start with something that is kind of basic, but I just need to know, what exactly is bankruptcy?
That's a great question. Bankruptcy was designed specifically to give people relief from their debt. It was all founded on the premise that people would never create or invent or open businesses or employ people or take chances and risks or really improve our communities if there wasn't sort of a fallback plan. And so bankruptcy was designed to help those people who took those chances and took those risks, and maybe they fell short one time. So it's all designed on the idea that people deserve a second chance, and this is the way to wipe the slate clean and give those people their second chances.
Oh, I love that. I love that. Okay, let me ask you this. There are different kinds of courts. There's federal courts, there's state courts. Where does bankruptcy happen?
Well, federal law governs bankruptcies. So it's sort of a combination of law. That's a really interesting question from a legal standpoint. But there is a federal bankruptcy court that is going to oversee every bankruptcy case that's filed in the state.
Okay.
Missouri is divided into the Eastern and Western District. The District of Kansas has one district. And the state law, the exemption laws, are what apply to your case. So even though it's housed in federal court and it's overseen by the bankruptcy court, you're going to use state court exemptions, and some state law may apply to your case.
Okay. And now, but actually the physical courthouse they would be going to is the federal
You
courthouse.
are not going to go to the Kansas City Municipal Courthouse. You are not going to go to the Jackson County, Missouri Courthouse or the Johnson County, Kansas Courthouse. You're not going there. You're going to the federal courthouse for your state.
Okay.
In Kansas, it's housed over at 5th and State Avenue. It's a big building downtown in KCMO. It is a very beautiful building, actually, but it's the federal courthouse. They do see other cases in that courthouse other than bankruptcy, so it's not specifically designed for bankruptcy court. But there's a floor that all the bankruptcy hearings are held on. It's the 6th floor. The 341 meetings for every bankruptcy case that's filed in the state are all held at the courthouse. They aren't necessarily held in a courtroom.
Okay.
I think a lot of that is designed intentionally because there are a lot of individuals who file. They may or may not have had a lot of experience in the legal arena. They've never been to court. So in order to make it a little less intimidating and house enough people, they're held in meeting rooms at the courthouse instead of a courtroom.
I like that. Mm-hmm. Okay, so when we're talking about personal bankruptcy here, we're talking about people, married couples, I guess, what are the types of bankruptcy?
Well, every individual has the opportunity to file a Chapter 7 or Chapter 13 case. They're designed very differently, and they're used to achieve different objectives usually.
Okay. Let's start with Chapter 7, and then we'll go to Chapter 11. Unless you think we should start with Chapter 11 and go to Chapter 7.
Well, I think we should start with Chapter 7 because usually the goal of every single individual, whether you own a business or not, whether you live on Social Security or you have a job, or regardless of your situation, usually the goal of every individual walking into my office is to file a Chapter 7.
Okay.
And there are several reasons for that.
Okay.
One, it is infinitely shorter than every other chapter you can file. It wipes the slate clean. It forgives you of all of your debt. There is no repayment plan. And most importantly, it costs significantly less in attorney's fees.
Okay.
So if you can get in and out of a bankruptcy in 90 days and pay your lawyer half as much as you would otherwise, that is usually the goal of everybody who walks in.
Of course.
Chapter 13 is designed for individuals who don't qualify for Chapter 7.
Okay.
Or who have fallen behind on house or car payments and want to keep their house or car.
I gotcha. Okay.
So when you file a bankruptcy, every single debtor has to file what's called a means test.
Okay.
It's basically an income qualifying test. It takes 6 months worth of your income, averages it out, multiplies it by 12. That gives us your annual income.
Okay.
There is a median income level for every county in every state.
Okay.
And if your income is below the median income level for a household of your size in your county, you would automatically qualify for a Chapter 7 case.
Okay.
So if you're current on your house and car payments and you're below the median income level, it's pretty easy for you to just file a Chapter 7, wipe the slate clean, get your fresh start.
Okay.
If you are above the median income level, it doesn't mean you don't qualify for a Chapter 7. What it means is you don't automatically qualify for a Chapter 7.
Okay.
So what we have to do with your income qualifying test then, when I explain it to my clients, I usually explain it as though you're filing, it's the difference between filing a 1040 EZ for your tax return and a full 1040 and itemizing your deductions.
Okay.
If you're over the median income level, you got to itemize your deductions.
Gotcha.
So we go in and we take out all the expenses we possibly can and we pull everything we can out of your income. And at the end of this test, it spits out this magic number called your disposable income. If you don't have any disposable income, you qualify for a Chapter 7. You get your discharge, you go on your merry way.
Okay.
If you have some disposable income, though, you do not qualify for a Chapter 7, and you're required to file a Chapter 13 plan.
Okay.
The Chapter 13 cases in those situations are designed for people to restructure their car loans so that they can pay back a little bit of unsecured debt. So your car loans get restructured. If you had a loan on, let's say you went to Rent-A-Center and you were renting a couch and you owed a debt, or you owed some money to Nebraska Furniture Mart and they took a security interest in your couch, or whatever it is that you purchased.
Okay.
Those sorts of things you can restructure in a plan. And then it sort of cuts you a break so you can pay some of your unsecured debt. Now, most people aren't going to pay all of their unsecured debt back in a Chapter 13, which is what a lot of people think.
Yeah.
But for example, if you owed $100,000 in credit card debt and your disposable income plan said you could afford to pay back $100 a month, you pay back $100 a month for 5 years, which is a total of $6,000. And at the end of that plan, you're still going to get the same discharge you would have gotten in a Chapter 7 case, but you only get it at the end of your Chapter 13 plan.
Okay.
So you pay back $6,000, you get a discharge of the other 94.
Okay. Is on the Chapter 13, is that 5 years set in stone? Is that like...
No, that's another great question. So a confirmable plan can run anywhere between 36 months and 62 months.
Okay.
So the trustee's office will confirm a plan if it's running a little bit long, 62 months. What the law does not allow you to do is what we call indentured servitude.
Right.
And it won't let you just hang out in a bankruptcy forever.
Yeah.
You have to complete within 5 years. You have to make your payments on time. And what sometimes happens with Chapter 13 cases is if you fail to make a payment, all of a sudden your plan that was running 60 months is now running 61. And then if you fail to make another payment, now your plan starts to run long.
Okay.
So depending on how many payments you miss,
right,
all of a sudden your payment has to go up in order to complete within the statute of limitations,
okay,
as a lot of people would like to call it.
Okay.
The really cool thing about Chapter 13, there's a couple of really cool things about Chapter 13s. And although they are significantly more expensive than a Chapter 7 case, They require a lot more time. They require a lot more work. I mean, you're hiring an attorney for anywhere between 3 and 5 years.
Okay.
So it's going to cost more.
Yeah.
But number one, in a Chapter 13 case, typically your lawyer is only going to require you to pay a minimal retainer fee. And then they get paid all their attorney's fees through your Chapter 13 plan. So every month when the trustee cuts your creditors a check to pay your car loan or your mortgage, they're going to cut me a check for my attorney's fees.
That's good to know.
So I only require a $500 retainer fee.
Okay.
Plus the filing fee to be paid up front.
Right.
And then the rest of my fees are paid through the plan.
Okay.
Now that situation might differ depending on, again, the complexity of your case, or if there were special circumstances. If your house is getting sold next week, that's a different situation. That's an emergency, and there may be different circumstances for that.
Right.
I do file some Chapter 13 cases on an hourly arrangement. Those are for people who just have unique situations, difficult circumstances. And we don't know how much the case is going to cost. Sure. And so a lot of those people will opt for an hourly arrangement just to make sure, they don't have to worry about getting charged every time I send them an email, or that my response isn't going to be long enough for their complexity of their issue, because we're on a flat fee arrangement.
Right.
So some of those people prefer that individualized attention, which is perfectly fine. And there are other ways to get paid for that.
Okay.
The other cool thing that you get to do in a Chapter 13 that you cannot do in a 7 is you can restructure those car loans. So a lot of my clients come in and they bought a car because they traded in an old car. They owed more money on it than it was worth. And so they roll those balances into a new loan.
Yes.
A lot of people do that.
Sure.
And before they know it, they owe $30,000 on a $10,000 car.
Yeah.
So in Chapter 13s, depending on when you bought the car, sometimes you can pay to value instead of the loan amount.
Right.
So you might be able to knock 20 grand off a car loan.
Yep.
And a lot of those $30,000 car loans are paying $500, $600, $700 a month.
Right.
Well, if you're in a Chapter 13 case, even if you don't qualify to pay to value, you do qualify to restructure the loan and pay the balance off over that 5-year period at a discounted rate of interest. Many of my clients come in and they are paying 15, 20, 25% on their car loans.
Right.
And they just can't manage it. They're just never going to pay the balances off. And you get the trustee's rate. At this point, I believe it's below 5% in a Chapter 13 case. So it's kind of a no-brainer.
Manageable.
Even if you qualified for a Chapter 7, you could opt to file a Chapter 13 instead, because you want to keep your car, you need reliable transportation to get to work. And this is a way to make that car loan more manageable for you so you don't lose the car.
Okay. All right. That is such valuable information. If somebody comes into your office and they are like, I'm getting calls by creditors, I'm freaking out, what things should they bring to you when they are first coming to do a consultation with you? I mean, I'm sure via phone or email you've told them what to bring. What are they walking in the door with so that you can begin the determination of, hey, what are we doing here?
Great question. Some of my clients walk into my office with nothing.
Right.
and you really can.
Yeah.
You need some basic information about, what do you own? Who do you owe? And a rough estimate of how much you owe.
Okay.
I'm going to teach you how to run your credit report. I'm going to teach you how to gather the information that I need in order to assess who your creditors are and how much you owe them. But if you know a rough estimate of what you owe, particularly in unsecured debt, so that we can assess if bankruptcy is even appropriate for you.
Right.
The first question I would hope everybody who's contemplating bankruptcy asks when they walk into their lawyer's office, you should always ask, is this appropriate for me?
I love it.
Do I have other options? Because some people do.
Right.
And bankruptcy isn't appropriate for everyone.
Okay. So that's good. This segues into the conversation the question, what are 3 questions if somebody is contemplating bankruptcy, has an appointment with a lawyer or is talking to lawyers on the phone, what are the 3 questions they should definitely be asking a lawyer?
3 questions that I would ask are, is this appropriate for me?
Right.
If so, what chapter am I eligible to file? And 3, are there any problems with my case?
Okay.
If your lawyer can't tell you those things,
Go find somebody else.
go find somebody else. And to be perfectly honest, your lawyer may not know what chapter is appropriate for you when you walk into their office because of the income qualifying test.
Right.
You know, if you haven't brought 6 months worth of pay stubs and have an hour and $500 to pay them to do your income qualifying test right there, they may not know.
Right.
But they should be able to articulate to you, if you don't qualify for a Chapter 7, here's why.
Right.
And if you don't, here's the plan.
Right.
We're going to file you in a Chapter 13. We're going to do debt settlement. We're going to call this vendor. We're going to call this credit card company. You know, here's what we're going to do if that doesn't happen.
Okay.
Because if then an income qualifying test usually takes about an hour to complete.
Okay.
And if you have not brought all of the documentation to do that and a little bit of money to pay the lawyer to complete it, they may not be able to give you any sort of guarantee as to what chapter you're going to file.
Okay. That makes sense.
Mm-hmm.
Now, what if, you said Chapter 13, they can repay in the midst of, they can pay for your attorney fee. I apologize. They can pay for your attorney fee. What if somebody has no money and they're going in Chapter 7? Is how you charge it just a flat fee and they're just going to have to figure out how to come up with the money for it?
Well, most of the time I tell my clients, I do get a flat fee in a Chapter 7 and it has to be paid before the case can be filed. Mainly because I see a little bit of a problem, a little bit of a conflict of interest in being a creditor on the day I file a case for somebody.
Right.
That's a problem for me.
Yeah.
It's not to say that there's other attorneys who feel differently about that, but my personal view is I think it is much more clear from an ethical standpoint if you go into it and I'm not owed any money.
Right.
But if you quit paying your credit card debt, which is what's going to go away when you file a Chapter 7 case, would that free up a couple $100 a month or $50 or whatever it's going to be so that you can save up that money to pay the fee?
Right.
What we see in Chapter 7 cases is there's a surge in the spring of filings.
Right.
Because people do their tax returns and they get a big tax refund and they take that and they pay their lawyer and their case is filed and they're out from under all of their debt. That's what you see a lot of.
Yeah.
And then you'll kind of see that surge again in August, September, October, perhaps because people have filed extensions.
Yes.
And then they finally get them filed.
They get their money.
The same thing.
Okay.
Yeah.
That's good to know.
That's not to say that there are not a whole lot of grandmas who are paying a fee or brother or sister. It's perfectly fine to do that. What's not okay is there's a very hard and fast rule in bankruptcy court about preference payments. So if mom or dad or family member or friend loan you money and you pay them back within 1 year prior to your bankruptcy filing, that is an insider payment. It can be voided by the trustee, and they go back to mom and dad and they say, hey, that's a no-no.
Wow.
I want my money back.
Okay.
And so they get the money back and they pay all of the creditors evenly.
Okay.
Because even though the debtor may see mom, dad, friend, family member differently than they see Bank of America, Chase, Visa, Discover Card, the law doesn't view mom and dad differently than Bank of America and Chase.
Sure.
So it's not fair to pay mom back and not pay Bank of America back. So you got to pay everybody evenly.
Right. Okay.
So it's a big no-no. It's just something to be aware of.
Sure.
You've basically got 2 options at that point. If you've done something like that, you can wait a year to file.
Right.
Or you can go into it and make the trustee an offer to settle it so that they don't go after mom and dad.
Okay. Okay. That's That is,
if you have a reason you need to file immediately, you can still do that, and you can still protect mom and dad if you want to.
right.
But it's going to cost you a little bit of money.
Yeah, you've got to get right with them.
Right.
Okay.
Exactly.
Okay. So in addition to an attorney fee, what else can somebody expect when they're filing for bankruptcy or seeking out bankruptcy? What other money is involved in it? Is there filing fee?
The filing fee.
Is there service? I mean, just whatever.
There's not service.
Okay.
The fees associated with filing a bankruptcy in a Chapter 7, it's $310. In a Chapter 13 is $335.
Okay.
For a Chapter 11, it's over $1,000.
Okay.
It's pretty expensive.
Okay.
So there are ways to pay your filing fee in installments. There are ways to ask the court to waive your filing fees, but they're very strict requirements. It doesn't happen very often, and you've got to have a good reason for it.
Sure.
And it can't be because I don't have $300, because everybody who files for bankruptcy doesn't have $300.
Right.
So there's got to be some unique set of circumstances in order to try to circumvent that.
Yeah. Okay. Okay. That makes sense. All right. So give me an A to Z. Somebody comes in, let's say a married couple. Let's do a married couple comes in. They're under a lot of credit card debt. Give me their A to Z of what happens during the pendency of their case. And just typical, I know there's exceptions and everything, but just sort of this is how we're going to attack this.
I will walk you through a 7, and then I'll walk you through a 13 because
Perfect.
they're different processes.
Great.
When my clients come in for a consultation, one of the pieces of paper that they leave with at the end of that consultation is a timeline, and it outlines everything that's going to happen in a typical bankruptcy case. So usually there's about a month of preparation.
Okay.
Somebody comes to see me a month, 2 months, 6 months later, however long it is, we get their case filed. So I have a list of documents that I need in order to prepare the case. So over that month or two, the client comes back and presents all of those documents to me. I prepare the case. We set an appointment for them to come in and sign all of their paperwork. They get to review it in detail prior to signing, so that we can correct any errors, any miscommunications. Once they've signed the paperwork, we pick their filing day. Once the case is filed, all debtors are protected by what's called the automatic stay. It puts a hold on any proceedings against you. You can't get sent collection letters. They can't call you on the phone. They can't repossess your car. They can't get a judgment against you in court. They can't garnish your wages. They can't do any of those things because that's what's protected by the automatic stay.
Okay.
Once the stay is in effect, 30 days later, the debtor has to make one court appearance. It is a 341 meeting of creditors. It is held in a meeting room at the federal courthouse. It is probably the most uneventful court experience of anyone's lifetime. They ask a variety of questions that are very standard. They're required by law. What's your name? What's your address? Are these the tax returns you filed?
Okay.
Things like that. And it's sort of a cattle call.
Sure.
There's 50 people in the room. Everybody's doing the same thing. Everybody's asked these questions. There may be a few questions that are specific to your case. If you paid mom and dad a preference payment, they're probably going to ask about that. If you are involved in a lawsuit, they're probably going to ask about that. Just a variety of things. It will go very quickly. At the end of the hearing, I walk outside with my clients, and I have yet to have a client say anything other than, that was it.
Yeah.
So, but that's kind of what you want.
Sure.
There may be additional documents that they request at that hearing. You usually have 10 days from the date of the hearing to get those back to the trustee. He or she reviews them. Usually it resolves whatever questions they had. And then after the 341 meeting, 60 days later in a Chapter 7, you get your discharge.
Wow.
There are 2 rounds of credit counseling you're required to complete in a Chapter 7 case. One before you file. Okay. You get a certificate. You file the certificate when you file a case.
Okay.
But the second round you have to complete after the case is filed. It takes about 2 hours. Most of my clients do it online, on the internet at night or on the weekend, whenever they want. And again, you get a certificate, you file that with the case, and you have to complete that credit counseling requirement before the discharge date or you don't get your discharge.
Okay.
So once the discharge is entered, the case usually closes within, sometimes it'll close instantaneously. Sometimes it takes a week to close. Sometimes there's a report that the trustee has to file because they're administering an asset, things like that.
And then their debt is gone.
That's it.
Okay. Yeah.
Second chance city. I mean,
yes.
wipe the slate clean, get your fresh start.
Right.
Don't hide from your creditors. A lot of those people haven't opened their mail in months because it's just bills and bills and bills and bills and bills, and they don't have any money to pay them. And so they stop opening the mail. Think of how freeing it is that they get to walk to their mailbox and they don't have to worry about receiving a stack of bills this tall that they can't pay.
I love it.
It's great.
I love it.
Yeah.
All right. Let's do chapter 13.
Okay. Chapter 13 is similar in the pre-stages.
Okay.
Again, there's a list of documents I'm going to need to prepare your case. You come in, you sign the paperwork, we pick your filing day. Once the case is filed, the automatic stay is in effect. 30 days later, you go to a 341 meeting of creditors. After the 341 meeting, usually it takes anywhere between 2 and 6 months to get a plan confirmed by the court. It is not unusual to have to file more than one plan. It is not unusual to have to amend your plan after the case is filed. So in a Chapter 13 case, in addition to all of the Chapter 7 paperwork you file, you also file what's called a Chapter 13 plan. The plan is reviewed by the trustee. The plan is reviewed by all of your creditors. They are allowed to make objections. You make adjustments. You amend your plan. So when I explain what's going to happen to my clients, what I usually say is Chapter 13 plans are kind of like that math problem you hated in the 8th grade. Train A leaves North Carolina going 40 miles an hour. Train B leaves Sacramento going 80 miles an hour. The initial plan is really just trying to determine what state everybody's going to meet in.
Okay.
Everybody objects, you amend, then you find out what county you're going to meet in.
Okay.
And once you've narrowed it down to a certain point, the court will confirm your plan.
Okay.
You have to make everybody happy in order to get the plan confirmed.
Okay.
Once the plan is confirmed, there is a bar date that is assessed in every Chapter 13 case. And what the bar date is, it is a date after your case is filed. I believe it is 90 days after your 341 meeting.
Okay.
So about 4 months after your case is filed, the bar date will pass. And if your creditors have not filed a claim in your case, they don't get paid.
Okay.
There are certain exceptions, taxes, a mortgage that's current, a car loan, things like secured debt.
Okay.
There's a lot of wiggle room for those people because the lien doesn't necessarily go away just because you don't file a claim.
Right.
Things like that. But unsecured creditors, at the end of the day, if you have not filed your claim, you haven't filed it timely, sorry, you're not getting paid.
Yep.
Historically, about 40% of creditors file a claim in a case.
Okay.
So somebody who comes in who has 500 creditors and might owe a lot of money, in all likelihood, the number of claims that are going to come in is going to be pretty low. Now, somebody who owes 3 people $100,000, I mean, you can kind of bet those claims are probably all going to come in. So they may not meet that 40% standard, but a good average would be about half your claims are going to come in.
Okay. All right.
When the Chapter 13 case gets completed, so you're a good girl, you make all your payments in your Chapter 13 plan for 3 to 5 years, you've done everything the court has asked you to do, you get your discharge, just like you would in a Chapter 7 case.
Okay.
All the other debt goes away.
Okay.
The court is aware that over a 5-year period, things change, things happen, people lose jobs. People get better jobs. People get promoted. People die. And sometimes people get inheritances.
Right.
I've had 3 clients who won the lottery while their Chapter 13 case is pending. I mean, I've never won the lottery. I had 3 clients who won the lottery. I mean, it's kind of crazy. But things happen. Things change. If anything changes in your financial situation while a Chapter 13 case is pending, you always need to let your lawyer know. There are plenty of adjustments that can happen. Again, it's that math problem. Where are the trains going to meet?
Right.
And if this train speeds up or slows down, that's going to affect where those trains meet. So there are certain amendments and certain adjustments you need to make in your case in order to have it be successful.
So are you saying if they won the lottery or got an inheritance, that it would up their monthly payment or up their responsibility from the plan?
So that depends.
Okay.
The famous law school answer.
Yeah.
It depends on what month they're in.
Okay.
If you are not, if you are past the 36-month mark, you can buy out of your plan according to the terms of the confirmed plan.
Okay.
If you're not past the 36-month mark, you got to pay everybody.
All right.
But you got to pay everybody who claimed their money.
Right.
And sometimes they don't all claim their money.
Yeah.
The other thing you got to look out for is, you're not really supposed to be gambling in a Chapter 13 plan.
Yes.
And so there is the risk that the U.S. Trustee's office could come in and say, these people just won $1 million in the lottery, and that's not fair, and that's abusing the bankruptcy system if they don't pay everybody.
Okay.
So there
is
are
the lottery considered gambling?
Ooh. I would assume so.
All right.
I mean,
I guess it is.
Well, and a lot of people get really nervous when I ask them for bank statements after they filed, because all of a sudden they're going, oh, did I do something wrong? I bought some flowers at the farmer's market. Was that wrong? What did I do? What you're really looking for with those statements is, did you write a big check to your brother?
Right.
Is Harrah's Casino showing up all over your bank statement? Because that's a problem.
Right.
Really, really significant abuses. You can't go down to Sunset Spas and buy a $8,000 hot tub and on credit and then turn around and file bankruptcy the next week. You can't do those things. It's fraud.
Okay.
So those are sort of the things that you're looking for with bank statements.
Okay.
The people who are coming in who are really concerned about what's going to show up on their bank statements are usually not the people you're really worried about abusing the system.
Right.
It's the people who usually they weren't thinking. They had every good intention in mind, but you can't go pay for your daughter's wedding and file bankruptcy 2 months later.
Right.
I mean, you just can't do those kinds of things.
Okay.
It's usually people who are very well-intentioned, who weren't thinking about how this would affect their financial situation that end up getting in trouble.
Sure. Okay. You have mentioned the role and the word trustee. I want you to tell us what is a trustee and their role in bankruptcy.
That's a great question. So
I have lots of them.
You do have such good questions. Well, the function of a trustee essentially is to represent the creditors you specified in your bankruptcy case. So they are the lawyer for the creditors.
Okay.
The Chapter 7 trustees have what we call liquidating powers, which means that they have the power to seize your assets that are not exempt from your bankruptcy estate and liquidate them. So sell them, take that money, and pay your creditors evenly with them. Okay. That's what liquidating powers do.
Okay.
Normally, there's a whole lot of things that you can liquidate in a Chapter 7 case, but if you're talking about a no asset case, it means that the debtor has no assets that are not allowed to be exempted by law in the bankruptcy, which means there are no assets for the trustee to administer. That's a no asset case, which means you can keep everything.
Yeah.
If the trustee states that they're going to abandon your property, that's a good thing because they're giving it back to you. They don't want it. The estate doesn't want it. It's not property of the estate. Do with it what you want.
Okay.
If the trustee needs to liquidate something, you will be well aware of that.
Okay.
They will be all over it.
Okay.
Now, a Chapter 13 trustee does not have liquidating powers. So they're not going to seize your car and take your car and go sell it and use that money to pay creditors. What they are going to do is collect payments from you.
Okay.
And so they're the bank.
Okay.
Every month when you make your plan payment, it's really a combination of car, house, and whatever unsecured debt you're supposed to be paying.
Okay.
Taxes, attorney's fees, etc. Those things are all paid in it. Child support, arrearage, that can be paid in it.
Right.
One of the things you have to attest to in order to receive a Chapter 13 discharge, you have to attest that you are current on your child support payments. It's very important.
Right, of course.
So the trustee is simply going to collect payments and disperse them.
Okay.
And they are paid a fee for that. So the Chapter 7 trustees get paid based on how many assets they can collect.
Okay.
A Chapter 13 trustee gets paid based on the amount of money they collect.
Okay.
So they have a vested interest in making your plan payment as high as possible.
Okay.
And the debtor's attorney has a vested interest in keeping your plan payment as low as possible.
Sure.
So those two things tend to have to meet in the middle somewhere.
Right. Yeah. Is there anything that cannot be discharged in bankruptcy? Because I've always heard student loans cannot be discharged in bankruptcy. So is there something, or if, say somebody has has engaged in negligence and there's a judgment against them for, a large amount, can they discharge that in bankruptcy?
Those are good questions too.
And it depends.
It does depend. There are always exceptions, but standard answers are, you're not going to get rid of your student loans.
Right.
You're not going to get rid of tax debt.
Yeah. Okay.
You're not going to get rid of child support.
Yep.
If you were drunk and got in a car and killed someone and they got a judgment against you, sorry.
You're not getting rid of that.
Not getting rid of that.
Okay.
But there are processes that have to be put in place. There are processes the creditor has to go through in order to preserve their debts too.
Sure.
You can discharge student loans if you sue the creditor in your Chapter 13 case. It's called an adversary proceeding.
Okay.
And it's basically the bankruptcy court's litigation arena.
Okay.
So you have to sue your student lender and you have to prove a hardship. The burden of proof is incredibly high. So not only do you have to prove that you cannot afford your student loans now, you have to be able to prove that you will never, ever, ever, ever be able to afford them ever in your life.
So maybe a disability.
Perhaps some of the case law that I've seen, people being successful, extreme handicaps with children involved, who also have their own problems.
Yep.
One case I read, a guy was in a vegetative state in the hospital, in coma.
Yeah.
Really, really extreme situations. I would say, people who owe a couple $100,000 and aren't making very much money, there's a possibility that you might be able to discharge them. But again, the burden of proof is really high.
Sure.
And student loan creditors, they have money and they have lawyers.
Yeah.
And they know that it's really hard to discharge student loans. So what they try to do is paper people to death.
Right.
So that usually the goal of a student loan adversary proceeding is to try to go in and renegotiate your student loans with the creditor so that we can get a settlement agreement on file. It's more affordable than any other options that you have.
Sure.
That's usually the best goal. And I don't like to approach those with the idea that the goal here is to discharge all of your debt, because the likelihood it's going to happen is pretty low.
Right.
The other thing, taxes can become dischargeable if they have been filed into a knowing for more than 3 years. If there's no tax lien against you, it is possible that they have lost their priority status and they become dischargeable just like credit cards do.
Good.
There are also instances, I have a lot of people who call me who are suing somebody for fraud in state court, and lo and behold, that person files for bankruptcy.
Right.
Well, that doesn't necessarily discharge your debt.
Right.
So it's important for you to understand your options.
Yeah.
At that point, you could come see me or a bankruptcy lawyer who can file an adversary proceeding. The fraud level that you have to prove in bankruptcy court is higher Then the fraud elements you have to prove in state court.
Okay.
The bankruptcy court gets to determine whether your fraud has risen to the level of non-dischargeability. It's a high burden of proof. And one of the conversations I always have with people is that, even if you win, even if the debtor did commit fraud, even if you get your judgment, you're right, you win. You're trying now to collect against a person who is admittedly broke.
Right.
So what do you think you're going to collect?
Right.
The success stories in those situations are people who are typically in Chapter 13 cases.
Okay. They've
got a plan. They're being successful in their plan. And we can build our settlement agreement or our judgment or whatever it is. You can build your award amount into the plan, but you're still going to get paid last.
Yeah.
So it's going to take you a while to get paid.
Yeah. Yeah. All right. That is good. All right. So I want to ask you, what are questions that I'm missing? What is something that if somebody is contemplating bankruptcy, they're watching this video, and I haven't asked you something that I need to ask you?
A lot of people ask me how this is going to affect their credit. Totally legit question. Valuable information to have. The question is, nobody really knows.
Okay.
So it's going to depend on how bad your credit is to begin with.
Right.
Most people walking into my office have really bad credit.
Yeah.
So I have seen instances where their credit goes up after a bankruptcy.
Sure.
A lot of times it's because of your income to debt ratio. So if I get rid of all your debt, all of a sudden you look like a pretty appealable, credit-worthy candidate.
Right.
I've had a number of clients who are in active Chapter 13 bankruptcy cases who want to go buy a house, and we can provide 1, 2, 3 years of payment history on their Chapter 13 plans, and they are consistently paying. They're on time. I mean, it's like clockwork.
Yep.
And those people get financed.
Yep.
Even in an active bankruptcy.
Yeah.
Now, normally your standard answer when somebody asks about credit is once your bankruptcy case is over, once it's closed,
okay,
it should take you 2 to 3 years to build your credit back up to the point that you can get financed as though the bankruptcy never even happened. The problem you need to be aware of is that you can't rebuild credit without having credit.
Yeah.
So the hard part is getting that credit.
Yeah.
And what I advise a lot of my clients to do is to go to one of the smaller lenders in their town, their hometown bank, and ask them if they can have a secured credit card, even if it's $500.
Yeah.
And you go to the gas station and you put your tank of gas on it every month and you pay it off. And you do that for 2 years, even if it's very small amounts. That's the way to rebuild your credit.
Okay.
It does not matter the amount of credit. It matters what you're doing with it. You have to demonstrate that you know how to use credit and use it responsibly.
Okay.
And that's how you're going to rebuild your credit.
All right.
The other questions I get a lot are, I don't want to include that in my bankruptcy. And that's sort of a false way to look at things.
Right.
Because everything is technically included in your bankruptcy.
Yep.
When you file for bankruptcy, you are an open book to the court.
Yep.
Your pleadings are a matter of public record. Anybody who wants a copy can go down to the courthouse and get one.
Right.
Your name is published in the paper.
Yep.
I don't know a whole lot of people who are sitting around on Sunday reading the bankruptcy notices in the back of the paper. But, some people, that's a really big deal to them.
I guess so.
But when you file the case, all of your creditors have to be listed. All of your assets have to be listed. Everything is disclosed. If there's ever a question about whether you report something, you err on the side of disclosure.
Right.
These are questions you have to answer under oath at your 341 meeting.
Right.
So you can't just not list a creditor.
Yeah.
And not be held under perjury.
Yeah.
Frequently, clients will forget about a creditor or forget about something. And it's usually a pretty easy fix. You make an amendment to the paperwork. You're not going to go to jail if you forget to list that payday loan you took out 5 years ago or something like that. But all of your assets are listed in the schedules. All of your debts, all of your co-debtors, their names, their addresses, your landlord, your lease. And assets are kind of tricky because you list all of your assets on schedules A and B.
Okay.
And on the day you file your case, those assets become your bankruptcy estate.
Okay.
And there are all these disclosures that are written. They were drafted by the credit card companies when the law got redrafted back in 2005.
Okay.
So they're designed to scare people out of filing for bankruptcy.
Right.
And they tell everybody all of your assets are going to be seized.
Right.
Which is sort of true and sort of false.
Right.
Because you do file schedules A and B that list all of your assets in your bankruptcy case. But you also file a Schedule C. And the Schedule C is what sort of pulls all that stuff off the table.
Okay.
Most people have all these exemptions that they can apply to their property, and you pull all of your property out of a bankruptcy case. If at the end of the day, there's still something listed there, it's more of a let's make a deal kind of situation.
Okay.
So if you have grandma's fur coat and you've got to keep grandma's fur coat and it is super, super, super valuable and there is no exemption that applies, then make an offer.
Okay. Yeah.
So,
all right.
There's always a way out of your problem.
Yeah.
The important thing, I think, is to be aware of the problem, to be aware of it before your case is filed.
Yeah.
And to have a plan of action for how you want to approach it.
Okay.
There are very, very, very few problems in bankruptcy court that cannot be solved. What's difficult to solve is if you are intentionally withholding information from your attorney and they find out about it at the creditors meeting, then it's a much more difficult problem to solve.
Right.
If you're as forthcoming as possible and disclosing as much as you possibly can, there's very, very few problems that we can't solve in one way or another.
Yep.
Sometimes it depends. It's going to determine whether you file a 7 or a 13.
Okay.
Sometimes it's going to determine whether you keep your house or not,
Yeah.
whether you keep that property,
Right.
or, can we sell that property, or, can you go buy another one after, 3 years from now, after the case is over and you just let this one go, or
Right.
certain things like that.
Okay.
So.
Well, obviously she knows what she's talking about. So if you want to get a hold of Betsy, her number's on the screen. It's also in the written text below the video. She is happy to answer your questions. I'm sure you do phone consultations.
Yes,
Okay.
I prefer phone consultations. And most of my clients do too. And I will hold them over lunch hours or in the evening or on a weekend, whenever you need them.
Okay. And so I hope you give her a call. She obviously has a lot of the answers. And I'm sure if she doesn't know the answers, she goes and looks it up and consults with people. So anyway, so anything else you have to add?
I think that there are a lot of problems that can be solved for people by just having the courage to pick up the phone and make that first phone call.
Oh my gosh.
I understand that it is scary.
Yes.
I understand that you are terrified. I understand that you are confused. And information is power.
Absolutely.
And you're not going to get anywhere unless you have the right information. And,
Absolutely.
A phone consultation, I offer a free 30-minute phone call. And I will be able to tell you if this is appropriate for you, if so, what chapter you're eligible to file, any problems with your case, and more often than not, I can quote you.
Right. Okay, great. And I think one of the things is there's some shame associated with this. If I couldn't make this payment, or I'm, kind of under this avalanche, and there is just no shame associated with this.
No.
And especially with your lawyer is there to be your advocate, be the help to you. And that's what she would do in this situation. There's just let go of that shame and get yourself in a situation where you do get a second chance.
I like to tell people that, more often than not, somebody's gotten sick, somebody's gotten hurt, somebody's died, somebody's lost a job.
Right.
There are all these things that happen to people that are totally beyond your control.
Right.
And you can't fix those things. But there are things we can do to fix the situation down below that's all getting affected by those services.
Absolutely.
You know, I can't bring your spouse back,
Right.
but I can make the loss a little more bearable by cleaning this up for you.
Yes.
And so I don't want people to feel like they have failed or that they're doing something wrong by calling me, because this is a responsible way of dealing with your problems. Well, like I said in the beginning, people would never think, invent, and create and open businesses if these remedies weren't available. There's a reason they're here, and they're here to help the people who need them.
Yes. Preach, girl. I love it. I love it. All right. Well, thank you so much for watching. I would love for you to subscribe to the channel or subscribe to my Facebook page. And everybody have a great day. Bye.